At the end of the day, the E-2 visa is not to benefit the individual necessarily. I mean, there are obviously some benefits there, but it's really, how is this benefiting the US? Being able to demonstrate that, there are individuals who are going to be hired, and not just like, hopefully they're not just minimum wage earners. Like, I hope the business plan is going to really be developed and show it's a real and operating business, and I'm going to need these number of individuals working for my business. It's really to benefit the US.
Patrick Findaro here, co-founder of Visa Franchise. Excited to have on immigration attorney Fadi Manawi with us today. Fadi, thanks so much for joining.
Thanks for inviting me, Patrick.
We've been working together for quite some time. I think potentially even before we started Visa Franchise back in 2015.
Right.
We had set up a relationship with your predecessor firm. And since then, we've had a lot of clients, principally for the E-2 visa, and that still remains the most popular category for our clients at Visa Franchise. And I think today, Fadi, it'd be good to just have a refresher on what is the E-2 visa, updates, talk a little bit about Canadians, but also folks from all over the world that are applying for the E-2 visa.
Yeah, definitely. It's been a really popular category for visas, particularly because it does offer a more independent way to get an actual visa. Sometimes when individuals are looking to, make their move to the U.S., they may start off by looking for job opportunities in the U.S. They may be looking at their employer. Does their employer have, an office or a relationship with a company in the U.S., and then, are able to do a transfer. But all of those categories are really under the sort of the control of the employer. Whereas with the E-2, it is really, makes it a lot more independent, right? So if a family is moving to the U.S. And they have set up an actual business whereby they have made an investment, the investment is at risk, it is a non-marginal business, then that individual can get themselves set up in the U.S., but also their spouse can get set up in the U.S. by being able to essentially work for any company in the U.S., including possibly the spouse's company that's been set up. So it does offer that flexibility, which is good for a family.
That's been a big change over the past couple of years, and even the last 6 months, with the technology sector kind of taking a hit, where software engineers, there was such a race for hiring software engineers.
Right.
Everyone was willing to sponsor H-1Bs or even TNs, but now that's just kind of frozen. Where we have mutual clients together that, hey, one of the spouses is the entrepreneur.
Right.
You can bring your own business down. You can buy a business, or if you don't really know what you want to do, maybe you don't have U.S. business experience, we can look at a franchise.
Right.
And then the spouse gets work authorization, where I've been seeing, salaries when you look, compared to Canada to the U.S., UK to the U.S., if not double, 1.5 times. And oftentimes the taxes are less. So as long as the investor is able to, get the business going, break even in a reasonable time frame for the family unit, it can make a lot of sense having that kind of package and self-determination to be able to move to the US.
Right. And not just that. I mean, if you're actually looking for a job in the US, one of the main questions that are going to be asked when you're going through the application process is, do you have authorization to work in the US? So if a spouse of an E-2 visa holder does have that authorization, then yes, that person can check off "I do" without feeling that they're fibbing about it, right? So because the reality is today there's a lot of companies that they don't want to necessarily go through the immigration process, right? So even for Canadians, where a TN status would be a relatively easy pathway to get work authorization, sometimes the companies are just not interested. They look at it as a sponsorship, and they have strict rules against it. So having a spouse that's already on an E-2, hopefully the spouse is being able to generate a decent income. Then yes, the spouse who is getting work authorization is able to do so, and are able to apply for jobs and indicate that nothing else is needed. I'm perfectly legal to work in the U.S. And by the way, there was a this was a change, and I know you're aware of it. But prior to 2021, I think it was in October of 2021, there was although spouses of E2 visa holders were always able to get the work authorization, there was a different process involved with that, whereby they had to apply for an actual EAD, employment authorization document, and that could take several months. So
Oh
although it
yeah, I
was,
remember back 2016, 17, clients taking 4 or 6 months
oh
to be able
yes,
to
yes,
work.
sometimes even
Where if you're
longer.
making 5K, 10K a month, that's a lot of money that you're
Exactly.
losing out
Yeah.
on.
So I remember having clients that were making arrangements whereby they did start the E2 business, but they didn't fully sort of, move to the US just because the spouse was not able to get work authorization at that point. But now it is incident to status, meaning upon entry as a E2 spouse, they do get the abbreviation of E2S for spouse, and that individual will be able to get the work authorization without having to apply for anything additional.
And Fadi, since we last had you on, I think it was the still like the COVID era or near post COVID era.
Right.
I think it was taking like 6 to 8 months to get the interview in Canada, UK, pretty similar processing times. But now it looks like pretty much across the board, maybe with an exception being Istanbul, Turkey, people are getting E2 visa interviews very fast, and the process can move quite quickly after you finalize the investment.
That's correct. So we've been seeing at current times, it could be a matter of 2 to 3 months before the individual is able to actually attend the interview at the consulate. Once they do attend the interview, they are, leaving their passport there and getting their visas issued, usually within a couple of weeks. So it is a much more streamlined process. But we do find that sometimes, depending on, I mean, it could be depending on a variety of different factors, but sometimes we do see a spike of applications, and then all of a sudden the applications are pushed back, and so. But to anticipate, a relatively quick turnaround period versus other visa types, it is definitely a really good way to go about getting an actual work authorization, getting a visa for the U.S. if that's the pathway that the individual chooses. And on that note, sometimes we have individuals that do not necessarily need to apply for an E2, so they do have other options available to them. So, for example, a person that has a business set up in the US or in their home country, but they are expanding to the US, they can choose an option like the L1, possibly if they qualify, but that also has its limitations. So with the L1, if the company is brand new in the U.S., that individual is only limited to a 1 year L1 by the time they
Tight.
apply. They can also, if they are from a treaty country that can apply for an E2, they can get an E2 for up to 5 years, depending on the country that they're from. So even from a strategic perspective, sometimes it's still better to go down the E2 path versus the other, visa types.
And we've had clients, go E2 to EB1C, which is typically the path from L1 to EB1C for the green card,
Yes.
in addition to EB2, EB2NAW, EB1A, spouse EB3. So
Right.
it's kind of a misconception that if you get the E2, you can never get a green card. And I'm sure you hear that sometimes in your initial consultations too.
Right. That's one of the most common questions that come up, Patrick. Can I get a green card, or when can I apply for a green card? The reality is, with the E2 standalone, it's not leading to a green card. In fact, you're signing a declaration indicating that you understand this is a temporary visa.
Yeah, you're
But
supposed to go back at the end of the term.
yeah, but there are other pathways, of course. So with my example, with somebody setting up or had a foreign business, expanding it to the U.S., whereby they would qualify for an L1, but sometimes going the E2 path is better because, first of all, the E2 might be issued for a longer period of time. The E2 does not have an end date, like expiration, that you can no longer have the E2 for, which the L1 does, which, depending on the L1 category, it's either 5 years or 7 years. But the more importantly, in that type of scenario where the person has a business abroad and is expanding to the U.S., you might open up the possibility of actually getting an EB-1C, as you mentioned. Many people would tell you that, well, you need an L1 as a prerequisite to applying for an EB-1C, but that's not the case. If you take a look at the regulations, you can technically, have a business abroad if it's operational, expanded to the U.S. So long as that U.S. business is older than 1 year and operational, functional, viable, then applying for an EB-1C might be a possibility.
What do you want to see for those cases? Because it does seem like there's quite a lot of Canadians and, well, people from around the world that have a business, maybe 10, 15 employees.
Right.
What do you want to see in terms of org structure in the home country, revenue, profits, where it's like, okay, this is a viable option that if you kick ass in the US business, you could potentially get a green card through this.
Right. Yeah. So it is a good question. And because, many times I can't tell you over the years, so many times I've seen this where, a person just thinks like, okay, now I have a foreign business, I have a U.S. business. Let's go for it. Let's do the EB-1C. But the reality is that, for an EB-1C or an L1A, you do need to show that, that the individual that is moving to the US is a senior manager or executive. So imagining what an org chart would look like for that. If you have, a one person company, that's a harder sell, right? You do want to show that there are, there's no minimum number of employees, but you want to show, for example, that okay, if the person applying is a senior manager or executive, I'm assuming there's a managerial level beneath that individual, and then beneath that individual, that line of individuals, there are also other workers, frontline workers, or whatever they may be. There is no minimum revenue levels that are required, but it has to make sense. That's the way you got to look at it. So if the company is doing well abroad and they've expanded to the U.S. and the U.S. has started hiring individuals, the U.S. companies really stand alone can support paying the salary of the individual that's being transferred. But also looking at it from the perspective that, yeah, standalone, it's a company that's doing well. It's on a upswing, trajectory. So it would make sense then to apply at that, maybe in that case for an EB-1C. But if it is a very flat business, if there's no real room for growth, then you may want to consider whether the EB-1C would be appropriate. Sometimes there's no hurry to apply for an EB-1C either, right?
For sure.
I've had clients that are particularly fond and happy to remain on a temporary status like the E-2 visa without knowing full well that, hey, I don't have to necessarily file my taxes as a U.S. resident, which has its own set of complications at times. But and the E-2 being available again year round without a cap and renewable indefinitely,
Super flexible visa. We have some very wealthy clients that the family might reside in Florida, Texas, California, and then the breadwinner is going back and forth and maybe counts their days and spends no more than 120 days in the United States. So they don't have to pay global income and don't have to worry about, estate issues down the line.
Right.
Fadi, I know we've had quite a mix of entrepreneurs, investors, and sometimes a franchise will serve as an anchor into the E-2 visa business, but we've successfully structured it where there's a holding company and then the franchise is down below, and it could be two partners that know each other 50-50 at the holding company level, two family members, two brothers, maybe they're both bringing their nuclear families down to the US. Can you talk a little bit about that strategy? Because you're, one of the minority of attorneys that employ that to give more flexibility and wiggle room to these E-2 visa investors.
That's a very good question. Having a sort of a setup the way you've described, it does allow for, I would say, some more flexibility for the E-2 investor to have possibly, other pathways for revenue generation. So long as this is all disclosed at the time of the application. That's important, and that can be disclosed in the application itself, but also part of the business plan, right? To show that this is what the business is. Maybe the business is starting off with one franchise. It could be it could be anything, but that they may also be adding additional franchises or going into a different business arena altogether. So long as it is disclosed at the outset, it has been a strategy that has been used in the past. It's been used successfully in the past. It doesn't give so many limitations that would otherwise be found within within the E2. So like I've had clients who didn't have the foresight of what they were going to be doing in the future, and they did start off as one sort of very one very, it could be a unique business, could be a general business, could be a franchise, could be anything. And then they come to me maybe 2 or 3 years later because they have an opportunity that presented itself, and they ask me, well, can I just can I continue working on this other business as well under my E2? And my answer is always the same. What was disclosed at the outset of the application? Because if it was not disclosed that you're going to be going into different areas of business, or it wasn't covered, then it could be a problem, especially when the individual is coming up for renewal and is disclosing that they've been involved in other businesses where maybe they should not have been. But if everything was already indicated at the original application, then at least they have that to go by, and they have the proof. It was submitted, it was disclosed to the consulate, and they shouldn't generally have a problem.
And it does seem like the holding company and opening it up. So, if you do retail investments, and the first business is a retail education business, but that opens you up to do other types of retail businesses, or
Right.
maybe mixing education together with an IT consulting business. We've seen that quite a lot because, especially from Canada, UK, there's a lot of people that are well paid in IT, 150, 200, 250 a year, making good money doing IT consulting, but it's not the best fit, when you look at the investment perspective from the E2. Right. So maybe there needs to be a little more weight to the E2 visa business, but give the investor the ability to do different things in the IT space as well as some other industries.
Oh, that makes sense. Um, the implementing this strategy over the years, I did find that it does create a lot more flexibility for the individual. So yes, having a holding company and then having these various businesses registered under that holding company is a strategy that can be used. And I believe I've worked with your clients as well, Patrick, and they've implemented that as well. But there are those out there that are, very narrow focused as to what they're going to be doing in the U.S. And they may run into some problems, if they do expand the business. To sometimes, an opportunity presents itself, and you feel you feel the need to jump on it, right? And you want to be able to do so
For
legally.
sure. And yeah, I guess there could be some options too, in terms of, is the spouse also going to be working in the business, and potentially
Right.
having the spouse, run with that business idea.
Sorry, just to mention that,
Yeah,
yes,
go on.
it is having the spouse have the flexibility of work authorization. It's not just to work for an existing business, but it can also mean setting up their own business. So if the E2 investor does find another business, they may want the spouse to head up that business and work for the business, right? So that it doesn't interfere with the underlying E2 investors' visa, if they did not have that flexibility set up in the first place. So I'm glad you brought that up.
That's a good plan B.
Yeah.
One thing that is kind of frustrating, but I guess, why people, work with us, is that the consulates adjudicate these very differently. Where, I don't know, I'd love to talk about, the differences in the consulates and what you see in Canada versus some other consulates where, for example, in Latin America, a lot of these consulates want to see the business open. They want to see a couple of employees hired, where that hasn't necessarily been the case in Canada, where it's been fine maybe not having the business open yet. And then other consulates like Pakistan, Egypt, they really hone on the intent to go back home,
Right.
and the connections that you have to Pakistan, the connections you have to Egypt, to show that you know, eventually plan to go back home, you know, after that initial E2 visa period.
Yeah. So the way that these are adjudicated can be quite different, as you're mentioning, across various consulates. By far, I personally work with a lot of Canadians. So dealing with the U.S. consulate in Toronto has been sort of my uh, main E2 consulate that I've been dealing with. But over the years, we have dealt with a number of consulates, as you're mentioning. Could be in South America, in Europe, and in Asia. And the adjudication, you have to know the little intricacies for what these consulates are looking for in order to best be able to apply appropriately, right? There are consulates where there is no even like a strict page limitation, right? With what's being provided, you can put everything together and send it off without having to worry about that. Whereas at the U.S. consulate in Toronto, for example, they're really making it a lot more streamlined, right? We have to get the application down to 50 pages now, right? Not too long ago it was
They
70
reduced it.
pages, and now they reduced it another
Yeah.
20. But I think that's also because they're getting there's an increase in the number of E2 applications, and you find that these E2 officers, they do move from one consulate to the next, but I think there is a inherent way that these E2s are adjudicated depending on where the consulate is. And as you mentioned, I mean, we had some clients in Pakistan where they did want to see what kind of ties the individuals had, whether it's in Pakistan, or maybe they are a Pakistani national but permanent resident elsewhere. They still need to establish that they are residing, they're intending to return to the country of residence. In some consulates, I find that although there is no minimum investment that's required from an E2 perspective, besides the fact that it has to be a substantial investment. So you won't find in the regulations a minimum threshold defined. In Toronto, for example, we've had a lot of leniency, I feel, depending on the nature of the business, as to this minimum substantial investment that's being invested for a particular business. But in some consulates elsewhere, that threshold is higher.
And what do you see? I guess that's a good segue. What do you really want to see of this E2 visa business before they go in to the consulate, before they apply for the E2 visa? Like, what do you want to see where it's almost kind of non-negotiable, where it's like, hey, you don't have these things done. I'm not continuing with you on this case because I don't have a high degree of certitude that you're going to get approved.
Right. So the parameters to getting the E2 is that there has to be a substantial investment. The investment itself has to be at risk. The business itself cannot be marginal. So the first point of there has to be a substantial investment, although maybe to you and I, it's a no-brainer, right? But for a lot of people I speak to, they including individuals that have already applied for the E2, and maybe they came back to me because they were denied. The actual investment being made at the outset, for many, they have not made that investment. So for example, they might say, well, I'm planning on buying this franchise or an existing business, whatever it may be, and they end up transferring funds to a perhaps they've set up a U.S. account and they've transferred funds from a foreign account to the U.S. account, and they said, "Here you go. Here's proof. Here's my bank statements." But that's not an investment that's being made. Because maybe those funds are going to be used for an investment, but what you want to find by the time the application is ready to be submitted is that the investment it's a real investment. So, for example, is there an actual buyer-seller agreement? Have you transferred the funds to the seller? Have you leased premises? Have you bought any assets if that's needed? There are workarounds to this, by the way, Patrick, and I know you're aware of this, but for the purpose
For
of our
sure.
viewers, Sometimes having using an escrow agency is a sort of a little bit of a workaround, and it's not. I mean, it's a workaround, but it's also defined in the regulations, right? That this is still can be seen as an investment. If a buyer is buying, a business for, let's say, I don't know, $150,000, but $150,000 is substantial no matter how you slice it. And if they feel that there's a reason that they don't want to necessarily go through that purchase because there's this question mark over their heads, are they going to get the visa or not? So they can go through basically, essentially the entire process, but having those investment funds sitting in escrow, and then that way, if it's contingent on the business being, or the E-2 being issued, then at that point the escrow funds are released. If
And that
not,
can be the only contingency, right?
correct. That's correct.
Which is important for everyone to know.
Right. Yeah. So this whole at risk, portion that's really where I find there's probably been the most mistakes made. I mean, now if somebody applied for an E-2 and it was denied for that reason, of course they can reapply for the visa. It is not there's not like a period of time where if there's a cool down period where before they can reapply again, they can apply immediately. But having to go
Yeah,
through that
no,
process.
unfortunately, we've had clients have to go back. It's less and less now, but
Mhm.
what you were mentioning with just like transferring the funds back in 2016, we had a client and we didn't know, better at the time, but they invested franchise fee, like say 40K, and then they
Right.
just transferred 60K into the bank account. But
Right.
they didn't have a lease sign. They didn't start opening. They didn't start the website. They didn't do all these things that you would do if you're about to open up a business. And
Right.
sure
Yeah.
enough, they went back, they bought a vehicle, put the logo of the franchise on the vehicle, spent money on Google ads, Facebook ads.
Right.
Their trip to the US counted, and then, they were at, 90K spent and then just 20K sitting
Right.
in the bank account for working capital. And that kind of did the trick.
Right. Yeah. It's a good story with respect to your clients because I've seen it. I've seen it countless times where, somebody comes to me and says, I've already applied for an E-2, was denied. And then you take a look, like you go through the record of all that's happened and, it becomes quite obvious, right?
Exactly. Yeah. If you were in there's been very few times where the denial didn't make sense,
Right.
where it's like, if I heard about a case and they said, this is what I did, and they're like, I was denied. It's like, oh yeah, it makes sense. Like
Right.
you were denied because you didn't do all these things. And
Right.
it does make sense why you were denied.
Right. And I mean, we can't overstate the importance of like this aspect to it because I can tell you even for clients that have worked with me directly, and you provide them with a list of everything they need to provide you, and then they say, okay, well, we have everything done. What's next? But when you take a look at what's actually been completed, including again the infamous just transferring to a U.S. account abroad, then it's you got to clarify that for the individual. I remember I had a client who was they had a business account set up in the U.S. And they actually got the bank to label it an escrow account that they
Hmm.
were in control of, right? So, sorry, the individual was in control of, but we had to clarify. No, that's still not what we're looking for, and but I mean, for the most part, I think there's a lot of now information online. There are people doing these webinars, podcasts, and so forth. So I think it is becoming I think less and less of a issue, but well,
Yeah.
hopefully I think
Yeah.
we have a more educated clientele.
Fadi, in the last month, I've had entrepreneurs from Pakistan, Canada, UK with already successful businesses in the US. And thinking about a couple of examples, one e-commerce store doing $1 million of revenue, making a lot of money, already has an American, doing content marketing. Another one on the consulting space. And these businesses were started for very little money. Like we're talking 20K, maybe less.
Right.
If the business is already successful in terms of revenue, they're hiring Americans, is it okay to have just invested, 20K into the initial startup of the operation?
It really does depend on the nature of the business itself. So even if you have a company that's been, that was started off with very little funds, and then 2 years later you look at it and it's doing really well, what I would do is kind of go back in time and say, okay, well, when this was started, during this period, was the investment substantial at that time? If it's questionable whether it can be accepted or not from an E-2, perspective, then with the success of the business, what did the individual do with those funds? Did the individual pay themselves and then maybe reinvest funds into the business? If so, then that should be outlined. That should be shown. But again, particularly in e-commerce, if an individual started a business with relatively like lower investment funds at the outset, it doesn't necessarily rule out applying for an E2. Right. It really depends on the nature of the business. Like, I compare if an individual is starting off a consulting business versus an individual that's buying a hotel. Right. I mean, I think these are two, really different types of businesses and require two really different types of investments. I think it's particularly okay for a business to get started off with less than what would maybe typically be seen as the minimum investment amount, so long as it can be demonstrated that this was appropriate at that time when this was started. And on that note, I have also seen there is a lot of misinformation with respect to how much is required for a minimum investment. I mean, I'm even talking about different law firm websites. They give you the threshold of 100,000. Another one says 150,000, and so forth. I don't think you can assign one number, one amount that can be used across the board, because it really does depend on the nature of the business.
And Fadi, I mean, we've covered a lot today. I just wanted to conclude, for those current entrepreneurs or would-be entrepreneurs looking to apply for the E-2 visa in 2025, what advice would you have for them today?
With respect to the E-2 process itself, it remains relatively unchanged from over the years. I mean, there are again sometimes little nuanced differences that you'll find at the varying consulates, but generally speaking, understand who your audience is, right? I know that we are also getting into, there's an election coming up. Is there going to be a change thereafter? Or are they going to be scrutinized or adjudicated differently? That's hard to tell. Depending on what the outcome is, but ultimately, being able to understand that, understand where even the U.S. is at. At the end of the day, the E-2 visa is not to benefit the individual necessarily. I mean, there are obviously some benefits there, but it's really, how is this benefiting the U.S.? Being able to demonstrate that, there are individuals who are going to be hired, and not just like, hopefully they're not just minimum wage earners. Like, I hope the business plan is going to really be developed and show it's a real and operating business, and I'm going to need these number of individuals working for my business. It's really to benefit the U.S. And the whole point to this is, there are varying accounts as to, how inflation is affecting the American populace, as, in its entirety. So being cognizant of that, and hopefully getting a business that's going to be set up that is ultimately going to be providing these benefits, then I think that that person would have a good shot in 2025 and beyond.
Awesome, Fadi. So there you have it. Thanks so much for sharing your wisdom on all things E-2 visa. And we'll be sure to put in the details, how people can get in contact with you, with your website. And Fadi, I just wanted to thank you again for joining us on Visa Franchise.
No, thank you, Patrick. I really enjoyed this.
Awesome, Fadi. Thanks so much.
Thank you for having me.